morning. Please be seated. This is the time set for oral argument in BAIRD against WHITTEN, our cause number SA17-0034. Counsel, we have reviewed the briefing extensively, conferenced the case before coming in today, so you can bear that in mind with the level that you start at in your presentation. We are being audio and video recorded today, and that recording will be made available to the public online and to you within the next few days. Each side has 20 minutes for oral argument, and the petitioner may reserve as much time as you wish, but you have to watch your own clock. We don't reserve it for you. And with that, if you'd like to begin.
May it please the Court, my name is Peter Meyer from Williams, Montgomery & John. I represent the petitioners Robert W. BAIRD and Company and HILLTOP Securities, Inc. I'd like to reserve at the outset approximately 5 minutes at the end. The petitioners here were underwriters in a 2005 municipal bond offering. And in 2009, the underwriters, along with other defendants, were sued by bondholders who alleged in part that defects in bond documents drafted and reviewed by the respondent lawyers effectively deprived bondholders of promised tax revenues. The underwriter's present lawsuit asserts negligence claims against the respondents' lawyers arising out of the drafting and review of those documents in 2005. And as part of their damages, they seek to recover their defense costs in defending the bondholder litigation. The underwriters seek a review of a January 24th order of the court, which held that the underwriters impliedly waived their attorney-client privilege with litigation counsel in the bondholder litigation. The order effectively permits discovery of all privileged communications during the course of that bondholder litigation, which spanned 5 years. We submit that there's no equally plain, speedy, and adequate remedy of appeal here. And we also submit the importance of the question because of the importance of having predictable and certain rules that govern the applicability of the attorney-client privilege and when it's waived. And we submit that the order that we're appealing from not only does not comport with Arizona law, but would, if followed by other courts, create that very uncertainty, because it effectively is some kind of a balancing test depending on the various equities of the case. We submit that the holding is contrary to Arizona law that it's developed on the issue of waiver since the Supreme Court's decision in State Farm versus Lee, including this court's recent decisions in the Akamozo and the Everest cases. And as set forth in those cases, it's very clear that merely filing an action or denying an allegation does not waive the privilege, and neither the relevance nor pragmatic importance alone of the information sought will support a finding that the attorney-client privilege has been waived. Rather, under Arizona law, a party does not impliedly waive the attorney-client privilege unless the party has in some way used that privileged information in aid of his or her position. For example, in the Lee case, the court found a waiver precisely because the insurer was defending the bad faith claim based on its subjective knowledge of the law, which had been informed by counsel. And in contrast, in the Akamozo case, this court found no waiver on behalf of a wife who disputed the enforceability of a prenuptial agreement because she was not doing anything, basing any positions on the fact or content of her communications with her counsel that had negotiated that agreement.
Now, in this case, things are a little bit different because I think, and stop me if I'm wrong, I think you would concede that the information sought is relevant to the theories in the case, and in particular the theories of damages that your client is pursuing.
We'd agree, Your Honor, that the information could very well be very relevant.
And that by asserting the privilege, you take a risk that you damage your own case.
Yes, that's true. But again, it's for us to make that decision,
Sure.
and not for them to make it on our behalf. And as I think the courts have clarified since Lee, that the mere relevance or importance of the information is not sufficient to waive the privilege. I think that was the point that was made in the Twin City case in the Supreme Court, where the court went out of its way to say, this information that you're seeking could be very important to the defendant. You could, in fact, find information that completely negates their claim that they had acted in bad faith, but the court said that's not sufficient. And it's clear here that we have not injected the advice of counsel into the case. The claimed negligence here occurred in connection with the offering that closed in November 2005. Litigation counsel did not represent the underwriters in connection with that offering, and the underwriters have not provided their experts with any privileged communications from litigation counsel, and the underwriters do not seek to rebut any defenses raised by the lawyers on the fact or content of communications with litigation counsel. And in fact, if you look at the record, Your Honor, there's nothing that the lawyers have asserted that says that we have done that.
On the issue of damages, it's tempting perhaps to treat the seeking of damages in the form of attorney's fees expended akin to a fee app in a normal contract case where the privilege generally is not waived. Do you see any difference in this case such that the absence of privileged communications might impair your damage theory to a greater extent than we normally see in fee applications?
I don't think so, Your Honor. We, in fact, have hired an expert to opine on the reasonableness of our fees and that they were necessary, and we haven't provided him with any privileged communication that we feel that we can put forward that claim.
And my guess is he thinks they were eminently reasonable.
Exactly.
But for somebody seeking to challenge those fees in a situation involving multiple parties, how are they to know? And again, this may be your choice just not to let them know and to forego those damages. But how are they to know with reasonable certainty what efforts were expended with regard to which potential tortfeasors?
Well, I think, Your Honor, I think we addressed this in our brief. The burden upon the plaintiffs in this case, the petitioners, is to prove that the defendants were a substantial cause of our damages. I think it's going to be our position that they should be responsible for all of our damages because they were a substantial cause. It's then, just as they've raised affirmative defenses and filed notices of non-parties of fault. It's their burden to prove either that the causes are divisible, or if not, then there's an allocation of fault. And frankly,
well, it would surprise me if the causes weren't divisible to some extent. I mean, we've all been in that position of defending multi-party cases, and sometimes you're working on one, sometimes you're working on another. Is it your contention that the billing records you submitted are adequate to allow that sort of apportionment?
Yes, I think there is, and in fact, their expert has opined to that effect. He's not only opined as to causation, but he's also opined as to the apportionment of the attorney's fees. And I submit, Your Honor, that they don't simply have the billing records, which, as they've pointed out, are 2,500 pages. What they have, they were both the lawyers and the counsel that's representing them in this case were participants in the underlying litigation. They have all the pleadings. They have all the deposition transcripts. They have all the expert opinions. Has their expert suggested that he or she would need this additional information? Not in their disclosures, Your Honor. He hasn't been deposed, but in his disclosure he simply says that the majority of the costs were not attributable to them. It was to other issues in the case. So, and I think Twin City made that point as well. You can't really argue that it's vital when you have access to an expert opinion that you can challenge that evidence on.
On this state of the record, though, is it surprising that the opposing experts wouldn't claim it was vital? It strikes me that that would be an unbelievable cross-examination point if they stated that at this point.
I agree, Your Honor. I don't know at this stage of the record, but we're basically facing the close of fact discovery quickly, or at least we were at the time that this issue arose. So I think the record is pretty well set. And so, you know, I can't answer what their expert would do, but certainly it's not our burden to prove that the lawyers were the sole cause of our damages. We just have to prove that they were a substantial cause. And then it's really up to them to try and either divide up the cause or if they can't do that, go to an allocation of fault model. I think we cited the tumbling cases, Your Honor, for that, where in fact they had the flooding, and part of it was possibly caused by the dam being insufficient, partly was caused by the district doing some things upstream. And ultimately how that case turned out was they weren't able to divide up the injury, and then the jury came up with an allocation of fault, which then effectively set damages. So I think they do have plenty to challenge our attorney's fees claim. And frankly, Your Honor, even in the situations where there's fee request, there often is allocations done by the judge as to a claim, this claim or that claim. So it can be done, and it's done without privileged information. And of course, as this court held in Akamazo, it's not enough that the issue is relevant, and it's not even enough that the issue is injected by the party claiming the privilege. The party has to go further and base its position on the fact or content of privileged communications. And again, we're not doing that. There's nowhere in the record that we are basing any claim or defense on the fact or content of attorney-client communications. The underwriters, or I should say the lawyers, also contended that we had waived privilege as a result of the lawyer's mitigation of damage defense, and that defense, as we understand it, is that somehow we should have settled sooner and thereby incurred less damages. And they argue in their brief that the underwriter's response that they could not have avoided the fees incurred, quote, implicitly relies on their communications with counsel regarding the strength of the multiple claims against them, their likely exposure with regard to the multiple claims, and the settlement posture of the opposing party. But I submit, Your Honor, there's no evidence in the record that the underwriters will seek to rebut this defense based on the fact or content of privileged communications with litigation counsel. We in fact represented to the Superior Court that we would not do so, but rely on evidence in the record to show that we were objectively reasonable. And as Lee pointed out, defending your conduct on the basis that it was objectively reasonable does not waive the privilege. And I would just briefly want to address the vitalness prong of the HON test. And as Twin Cities case made clear, it's not sufficient to establish that the information would be important or that it would be relevant. You basically have to be using the privilege as both a shield and a sword. And that's not something that we're doing here. We are not saying that our conduct is defensible based on information that we received from litigation counsel. We are making our claims and rebutting the lawyer's defenses without relying on any communications from litigation counsel. With that, Your Honor, I think I'd like to reserve the remainder of my time unless you have any questions.
That's fine. Thank you.
Thank you.
May it please the Court, John DeWolf and Shelley Tolman for KUTAK Rock. Your Honors, I'd like to set aside about 3 or 4 minutes to my co-counsel to speak on behalf of the Stinson firm. Thank you for taking time today for hearing this. This is a case, and the case law focuses on the issues of fairness and the fact-finding process. What we're faced with today is a unique case that is essentially an indemnification case. Unlike any cases that have been before this court, and we have cited indemnification cases for the court because we think that they are most applicable. The petitioners have not analyzed or challenged those cases.
Well, how is this case more like an indemnification case than any professional negligence case?
Because, Your Honor, what they're seeking to do is shift their fees from the underlying bond litigation to us, in this case, wholesale, dollar for dollar, roughly $9 million of fees and costs, and saying, in effect, that our negligence was the cause of all of those efforts by the lawyers in the representation of the underwriters that resulted in those fees and costs.
Yes, and I can well imagine that you probably disagree with that damage theory, but it doesn't seem to me to be any more indemnification than any other malpractice case that identifies damages flowing from the malpractice. I mean, it doesn't seem to me that we need to go to a different body of law and treat this as if it's a quasi-insurance case. It seems to me that we have a professional negligence case. There's a damage theory that may or may not hold water, but aren't the defense costs functionally a black box that can be analyzed through traditional approaches to reasonableness of fees?
No, Your Honor, and the reason is that, and I think you asked counsel whether isn't this like a fee application.
Yeah.
It's not like a fee application. Typically a fee application is after the underlying case on the merits has been completely tried. It's not a tort case any longer. This is a tort case seeking to impose upon the lawyers on negligence theories every one of those entries and every one of those efforts without disclosing what those efforts consist of, what the thinking was behind those efforts, why they were undertaken. And so what they're seeking to do is impose upon us, and I know you're about to ask a question, so let me.
Okay, go ahead.
So it is not a fee application. There are other reasons why it's not a fee application. Typically fee applications are driven by interpretations of statutes with developed case law, and the fact finder in a fee application is the judge who actually heard the matter. The party seeking the fees bears the burden of showing, in effect, they're entitled to the fees, and the analysis is an objective one. It really is not a subjective one or one that gets behind the efforts.
Let's say I agree with everything you just said. That bodes very well for you in terms of how this case comes out, right? You've analyzed a lot of flaws with the theory that may in fact be fatal to the claim. But how does that translate to waiver?
Because
you heard me ask before, if you make this choice to assert the privilege, you may kill your own case. And petitioners agreed with that assertion. If you don't, I'd be interested to know why.
Yeah, let me answer that with 2 comments. We are, as defendants, entitled to put on a defense, and the case law focuses on the fairness to defendants when the opposing side has put in issue, in play, in effect, the attorney-client privileged communications and work product privileged communications without allowing that to be disclosed for pursuit by the defendant. And here, what you're suggesting is, well, can we not simply say they haven't sustained their burden on causation because they haven't proved the causal link between the lawyer's efforts and the fees?
Right.
But the problem with that, Your Honor, is that if you look at the fees, and you asked co-counsel about our expert, Mr. Maladon, he has given an opinion. We would want more information for that opinion because we want to be able to explore actually what was done. And reasonably, their entries, because their communications, their fee entries between the client and counsel, they're cryptic and they're vague. And a jury, and this was a concern that Judge Whitten expressed, is that a jury as a fact finder will not be able to make anything out of 2,500 pages of invoices with 4,800 separate entries, and we're left with defending a case saying they haven't made their claim.
So if they have 20,000 pages of entries with emails and all sorts of privileged communications, that'll make it easier?
What will make it easier is if we can determine, and we have the right to explain to the jury, this is what they did here, and that did not relate to our client's wrongdoing. And this is what they did here. Because, and one of the things I wanted to clarify for the court is that the underlying complaint, and it is an appendix for your honors, it is a 90-page complaint, and it sets out a number of claims. There are 9 claims for relief with 15 defendants. It's a very complicated case, the underlying case, the bond litigation case. But the first 64 pages are dedicated to the wrongdoing of the underwriters and others having to do with the economics and the feasibility of analyzing the bond transaction. KUTAK and Stinson are not mentioned until page 64, 65 in a meaningful way, having to do with the bond document defects.
That again helps you on the merits. I guess this fairness notion, and I know Judge Catani has a question for you shortly, but this fairness notion troubles me. I don't mean to be crass, but I don't see anywhere in our attorney-client privilege statute a reference to fairness. The statute exists as an impediment to the search for the truth and can fundamentally have unfair outcomes at times, but it exists to serve what is perceived as a higher policy purpose. And the legislature has told us this privilege exists. Not it exists if it's fair, not if it exists if it's convenient. It often stands as a barrier to the discovery of very important information. So what's your best authority to say that we should just sort of determine what's fair?
Well, I wouldn't be saying that is all that you need to decide or think about today. What I'm telling you and what defendants are telling you is that the HON test is applied routinely, and it is the test that controls the analysis of the court. And it first asks the first element as has the client, the party seeking to protect the privilege, has it put into play by affirmative act the issue of privileged communications. The case law is very clear on this. The Elia Pfeiffer case, we've cited a whole slew of out-of-state cases. The Almari case out of the Ninth Circuit, again, issues where a malpractice filing is sufficient because it, under the Holloway case, which is a Washington case cited by Arizona with support and approval, says when you file a malpractice action, you have put those things into play and you have created a catalyst for making that an issue. The second issue, which I think Your Honor is asking about, is whether they have sufficiently put it at issue, that is, privileged communications, to make it a matter of requiring waiver in fairness to the parties defending the case. And I would assert to Your Honor that we have a right as defendants to be able to challenge the underpinnings and foundation of what it is that they're arguing to the jury. Because, and to illustrate the point, Your Honor, we have cited Brian Trexler's testimony. The panel will, I think, find that on page 14 of our brief. Mr. Trexler is the in-house counsel for BAIRD. And so we did not raise this privilege issue until late in the case because we weren't sure how much we would get in terms of disclosure and information that would provide a basis and a foundation for explaining and analyzing all of these entries in the invoices. And what we did was we asked Mr. Trexel, who is the only fact witness identified by the underwriters. He's an in-house counsel for the underwriter BAIRD. We said, can you explain these entries? He doesn't remember the entries and he can't explain them. Now, we then go on and ask the question. I'm sorry?
Then they might lose.
They may or they may not, but what they're going to try to do is purport to say all of this is caused by these lawyers, and we have the right to say no, it wasn't caused by us, and this is why. And the causal links not only go back to a bond transaction in 2005, they're causal links to defaults and remediation efforts in 2007, 2008, demand letters written by Allstate, the plaintiff in the underlying case, in May of 2009 that led to the litigation. And the notion that when they're defending claims having to do with their own wrongdoing, that is the economic feasibility of this project, when they as underwriters are endorsing the bonds to the buying public, could say that all $9 million of attorney efforts is associated with us is false and unsupportable. But we have the
Can I
right.
ask, though, if,
yes.
let's say their entries explicitly, carefully detailed exactly what the advice was going to, and which that this is going to a different defendant, advice regarding an issue that's clear goes to someone else who might have some responsibility. Would you need to have privileged communications if the billing entries were clearly delineating how the money was being spent regarding different issues? And if that's the case, I guess it's kind of a two-part question. When you're suggesting that it's an objective standard, it doesn't seem like the attorney's actual advice really matters. You're saying it's an objective standard, and your main concern seems to be, well, we can't tell what these efforts were directed at, and that goes to, I think, Judge Swan's point that then they lose, and that's their burden, and they haven't really delineated why you're responsible for that. And sorry for a long-winded question, but if that makes any sense to you.
It does. We're not saying it's an objective standard. We're saying that HON applies and the three elements apply, and under these circumstances, and of course, HON analyzes and applies itself to all sets of circumstances, and the underwriters have suggested it's only when subjective beliefs are at issue, for example, under the bad faith cases. But clearly, Elia, the ineffective assistance of counsels, the Molina case, all find waiver in other contexts. So it isn't driven by subjective beliefs or getting behind that. What it's driven by is the notion that the privilege has to give way to the fairness of the party being challenged to be able to defend their case.
Is there a case that says that? The privilege has to give way to the fairness?
Lee says that. Lee says that.
Well, Lee says that when the subjective beliefs based on communications with counsel is at issue. Lee doesn't have a general statement that privileges give way to fairness considerations. And I think until we cross that bridge, we're sort of stuck on the bank here.
Your Honor, the Lee says in that case, because the State Farm was raising, in effect, their good faith in a bad faith case,
right,
but they never raised advice of counsel. They never said that in response to Lee seeking the information between the privileged information.
And Lee determined that their subjective good faith had been placed at issue, and there can be debate surrounding whether that was right or wrong, but that's what Lee held.
Well,
their subjective state of mind was at issue. That doesn't seem to be at issue here. This is not counsel. The fees being sought are not the counsel who advised them. These are just people who defended him in litigation.
I frankly can't think of a case where lawyers' advice and conduct is more relevant and more important than in this case,
Again,
because
relevance
everything
is not the touchstone. We don't care if it's relevant. As a matter of fact, the
No, I
privilege is
understand.
meaningless unless it applies against relevant discovery, right?
Well, the third element, I think, where you're going is the third element of Hearn talks about how vital it is to defendants. And not only must the holder of the privilege, in cases of asserted waiver, not only must they put at issue, and here we would assert to the court that, in effect, when they seek all of their attorney's fees and costs in the defense of a case where they were a primary defendant, defending claims of their own wrongdoing, and where a federal court judge, Judge Snow, found there were at least issues of fact to go to the jury on their Arizona securities fraud acts, and found that the lawyers, in effect, were not culpable for bond document defects, except for very narrow areas. That clearly, those are issues, and I understand what
I just feel like we're still not getting to the issue. Everything you're saying sounds really bad for petitioners in the underlying litigation in this case, and I understand they may have a very steep uphill battle to get to any sort of meaningful remedy. But we're here talking about the privilege.
Okay.
And I have yet to hear a case that says privileges yield to fairness or relevance is the touchstone of the analysis or anything like that. What we have is Lee that says when you place the actual communications at issue because your subjective state of mind is a defense, then you've waived. Here, there's no such analog.
The Lee decision where the carrier put their subjective beliefs at issue was the triggering issue, became the way that they put at issue the privileged communications, which the Lee court then found was, in fairness, put it in a position where the other side had the right to explore those privileged communications to test the theory of whether, in fact, they had a subjective belief. And one of the sources of information upon which State Farm had gathered all of their grounds for asserting good faith was advice of counsel. And so they were allowed to explore those on the basis that it was fair to the defendants to be able to explore when those issues would be presented to a fact finder, and behind the scene, in effect, was this allegation of subjective belief. So, and I got away from your question, Your Honor. I
just want to give you a heads up that we're at the point where you had discussed a time division. You can handle it however you want.
I want to defer and allow co-counsel to let me just say one final thing on the vital issue, why this is vital. We've got allocation of fault issues. We've identified 6 non-parties at fault. We clearly have the right to explore what those events or efforts were that underlying those entries in the invoices, to know how any of those efforts related to some of the other co-defendants in the underlying case. We've also alleged avoidable consequences, mitigation of damages, as it relates to settlement, why they did what they did when they did it. We've alleged mitigation of damages as to why, for example, they had 5 lawyers do tasks that might have been done by 2 or 3. But without getting behind to issues of budgets, legal analysis, strategy, our hands would be tied as it relates to trying to explore that and explain it to a jury.
Your Honor, Kevin O'Malley for the Stinson Law Firm. Let me tell you the case. It's Throop itself, Your Honor. Throop itself is a causation issue. And when you look at Lee, it cites to Throop and talks about fairness. And it talks about the fact that if causation is at issue, the client in Throop did not voluntarily inject their subjective thought. It's got nothing to do with that. In that case, they said, look, if causation's at issue, the privilege needs to yield. It can't be a sword and a shield. Fairness applies. It's causation in this case. All their cases deal with, like Lee, subjective belief. And is it informed by advice of counsel? That's not our case. Our case is Throop.
How did they put this comparative fault theory at issue?
Because they are the causation issue, just like in Throop. The causation issue is at issue. They put it at issue.
Well, they put it at issue because causation is an element of every claim, but if that were the case, then we wouldn't bother with a privilege.
But here,
I think you put the comparative fault, or your side of the room put the comparative fault at issue.
no, it goes beyond that, Your Honor. If you look at the restatement on allocation, and this is what Judge Whitten was focused on, you have causation to their damages. Causation to their damages. And what the restatement says is that if it's possible to allocate, then it's a jury question on how to allocate. If we buy their theory for a second, what they said was, we believe we've met our burden of proof under Ontiveros by saying that our conduct was a cause, a proximate cause. Burden shifts to us. Now we have to put on evidence to allocate between the first theory, which was that they were involved in a fraud, and the second theory, which is that we maybe made some mistakes on bond documents. We have that obligation. They put it at issue by asking for all the fees, and they're going to sit there and tell you that it's our burden, and they're going to put up the shield and say you can't have any evidence about that. To respond to your question, Judge Zuma, Tom Slackett is going to testify that the overall fees were reasonable. That's all he's going to say. Bill Maladon's going to come in and say, based on the limited information I have available to me, it looks like the overwhelming evidence is that most of their time was spent on defending the fraud claim against them. Of course it would be. And we defended the lawyer side of the thing. So what if our motion for summary judgment, Judge Schwan, is denied? I agree with you. Their claim is weak. But what if it's denied? Then this jury has to do the allocation. Somebody has the burden. They say we do. They're going to just rest. You were a cause, and now you have to allocate it. How are we going to allocate it? Their witness won't answer the question, won't tell us
This
anything
isn't a
about
criminal
it.
case. You get to tell the jury all about how there's this information they won't give you.
Well, you know, I think what Judge Whitten was saying is, if I'm going to ask a jury, I'm presiding over this case, I'm going to ask a jury to make the determination of allocation in fairness. It's vital that these people, the defendants, have the opportunity to see why, from a causation standpoint, an allocation standpoint, why were these lawyers spending their time, and what were they spending their time on? And when we asked the simple question to Trexel, the only witness, they don't have any other witness, can you help us? What amount of time was being spent on this case? Sorry, that's strategy, protected by the attorney-client privilege. So maybe you're right. Maybe with Trexel's advice, maybe we get summary judgment. But what we're here about today, Your Honor, is to say it's not the client. That's the idea of an implied waiver. It's not the client making a decision. I'm going to waive or I'm not going to waive. Implied waiver, especially in Throop with causation, is by their conduct, by asking for all $9 million in fees and then telling us, go figure out a way to allocate that, but we're going to hide from you the best evidence. That's a sword and a shield, Your Honor. I'm sorry, I'm over my time.
Can I just follow up?
Sure.
The one point that I'm not necessarily getting is if it's just a question about how you're allocating, if it's a better description of fees, seems different to me than getting all kinds of privileged communications.
Well, you think about it. We had 2,500 pages, 7,000 entries. What do we think they have? I think what they have is a budget. And the budget's going to say, you know what, there's this big claim against us, and here's all the experts we're going to hire, and here's the motions we're going to file, and so forth. And then, after Judge Snow made his ruling, he made a ruling that we're not responsible for the fraud. We're only responsible for the bond defects. That's what Judge Snow held. So then I bet they go back and say, all right, maybe we ought to settle this case, because we're not going to be able to shove it off on the lawyers. There's a triable jury question on our fraud. I'd like to see the reassessed memo. I write them all the time for clients. I'd like to see what they said about why they spent $5 or $6 or $7 or $8 or $9 million on this case when we were there to defend. You're right. We were there to defend the bond defect case. John and I did that. But we didn't defend the fraud case against them. And they didn't defend the bond defect case against us. And we know that, and no jury's going to figure that out. Their own supervising lawyer said he couldn't figure it out from those timesheets. We need to get behind it and see what they were really spending their time on. And maybe we win on summary judgment, Judge Swan. Maybe we do. But if we don't, our hands are being tied here to a large extent by their assertion of the privilege with regard to causation and allocation. Thank you.
Thank you.
Your Honor, just to
Your Honor, just a couple of very quick points. At one point, Mr. DeWolf had asserted that our invoices are cryptic and vague. But if you actually look at the record, Your Honor, there's one page of our invoices in the record. It's at Appendix 375. And I think if you read it, it's pretty specific.
I don't know that that's our job right now, is to figure out the strength of your case.
Right, I understand
you
it.
may well be throwing your case right down the tubes.
I agree, Your Honor.
Assertion.
I agree. And frankly, a lot of their comments went to the merits of the case. You know, we have a lot to say about that. We're going to have evidence from the plaintiffs themselves as to why they filed the case and what was the real issue in the case. And, you know, who was sued for what. Again, Your Honor, the complaint is in the record. I think we were all sued over all of the claims. And the allegations against them as to the projections were the same allegations that were made against us. And so for them to say, oh, we're defending against only these claims were asserted against us, you know, as the evidence will show, the underwriters didn't even make the projections. Other parties did. So, you know, there's a lot to say on the merits. But on the privilege itself, they really haven't cited, he mentions the Throop case and the Elia case, but as Lee went out of its way to talk about all these other cases, and in particular in paragraph 26 of its opinion, it goes through the different restatement approaches. First one being, you can file a lawsuit, that waives the privilege. The second approach is a fairness balancing between whether the defendant really needs it as opposed to the need to keep the privilege. And in that, the court actually cited the Elia case as being an example of that. And the court goes on to say, we're not going to follow either of those approaches. We're going to go to the third approach, which requires the injection of the counsel's advice into the case. And it went on to say, look, our case here is more restrictive than some of the previous language in previous Arizona cases. And I think if you look at, for example, paragraph 38 of the Lee opinion, it goes through and says, look, we're going to presume in, you know, every case that you've conferred with counsel and that you've made subjective evaluations based on advice of counsel. But that's not enough to waive the privilege. And the reason why they found a waiver was precisely because they were relying on counsel advice to defend against the claim. And that was apparent. They actually quoted deposition testimony, I think it's in footnote 5, where the claims manager was testifying that he had no knowledge of what the law was other than what he had learned from the lawyer. And so it was clear. And they cited the Mendoza case in their papers. And again, that was a case after trial. They had a full record. And in that case, the defendant admitted that they were relying on counsel to make the very decisions that they were defending. And so that's not what's occurred here. And you're right. The only thing that's before this court now is the privilege. I submit to you that they haven't established that, in fact, there has been a waiver of the privilege. Thank you.
Thank you very much. To both sides, we appreciate the argument. It's an interesting matter, and it is now under advisement. We will issue a written decision in due course, and the court stands adjourned.